Yo, Patrick, how you doing, bud?
Not too bad at all, buddy. So there's been a bit of a decision in the U.S. courts on immigration policy.
That's correct. The 5th District Court has upheld a policy from a law passed in 1999 by 2-1. And the Fifth Circuit upholds Trump's administration mandatory detention policy.
Right. Okay.
So that is identified under 8 U.S.C. 1225 and 8 U.S.C. 1226, which defines what it means to enter the country illegally. And then this decision is based on language from that 1999 law that says that you shall hold someone who is in deportation proceedings. And we'll get into it into the article. So
yes. It's the words that they're getting caught on, I think.
The word shall, right? So it's a federal supremacy thing. The state and local jurisdictions, law enforcement jurisdictions, shall hold them. They haven't been doing that. They've been giving them bond hearings and habeas hearings and things like that when they didn't have to. They were rather relaxed, even though the verbiage was the word shall, right? So the way it is written, the 3-panel 2-1 decided that the interpretation by the current administration is actually the appropriate one. So I'll read. Christina Van Wasbergen, February 6, 2026. A panel of judges ruled 2-1 that government can lawfully require detention for all non-citizens in removal proceedings who enter the U.S. without being legally admitted, right? So it means they've been picked up by law enforcement for whatever reason. And if they have a whole...
Overstaying their visas and so on, I presume.
Well, that's 1225, 1226 under 8 U.S.C. How did you get in? Did you go to a port of call? Did you follow the appropriate rules? If you did not, you're not attempting to seek admission, you're just here, then they shall hold you, hand you off to federal authorities, and then they will complete the deportation proceedings. So.
It's okay.
All right, so we have President Donald Trump with Governor Ron DeSantis, Homeland Security's Kristi Noem on a tour of Alligator Alcatraz, Florida. Divided, Fifth Circuit panel ruled Friday that the Trump administration can lawfully deny bond hearings for many people in deportation proceedings, despite over 300 federal judges who have ruled to the contrary, which is interesting.
Yeah.
So they have ruled that although a law says a thing, they want the exact opposite thing to be the case, right? The conservative majority overruled federal judges in 2 separate cases, bucking nearly 30 years of federal immigration policy. Again, it's not policy because the verbiage says shall, requiring mandatory detention of applicants for admission only for individuals in removal proceedings who presented at port of entry or were detained shortly after crossing the border, while allowing detainees already living in the U.S. to request release on bond. So there was a comparison to if I did not pay to get into the movie theater and I was there for, half the movie, I still didn't pay to go into the movie. I did not enter appropriately, right? So,
and what was the procedure before this? You picked up, say, by federal authorities. You get detained, and you get a bond. You were saying,
right?
You're left out in bond,
right? So if you got picked up by federal authorities, it wouldn't be that way. It's state and local. So let's say you're in Podunk, Iowa, and you appear before the court, you could get a bond, and that bond would allow you to be released until such time as you come back for your criminal proceedings, right?
Okay.
But after criminal proceedings, you should have been handed directly off to federal law enforcement to complete the process of deportation, right? Because a lot of these final orders are 10, 12, 15 years old. They just stay in the country, right? You've watched almost the entire movie, but you still didn't pay. Right, you did not.
Yeah, I've seen that over the last few months, especially final deportation orders. People, as you were saying, 15, 20, 30 years in the country. If you're 15 or more years in the country, at that stage, you should have started the process at some time to become a citizen or gone through the proper procedure at that stage. Surely.
Oh yeah, that would make sense, right? Unless. For whatever reason, you don't know, you don't speak the language. Somebody in your family says, no, it's okay. We can do this because they're not actually enforcing the laws that they have passed. And then a lot of them pinky promise to show up and then never show up. Over 90% of those who get these hearings don't show up. And then people lose their mind when ICE shows up or other agents of the federal arms of law enforcement go to pick people up on their final deportation orders because a judge says, you got to go home. You don't live here. You're not a citizen. And then people get very, very angry when the police help them back to their country. Hey, you didn't do this right. And from what I understand, if you do it once and they send you back, you can still attempt to come back in as long as you follow the appropriate procedure, right? Like,
Okay.
look, hey, no harm, no foul. You did it wrong the first time. We're going to give you a second chance, right? So come to the port of entry, follow the appropriate guidance under 8 USC 1225 or 1226, and do it correctly. And then we will more than happily process you appropriately, right?
Mm.
So, in contrast to past administrations, the current administration has chosen to exercise a greater portion of its authority by treating applicants for admission under the provision designed to apply to them. U.S. Circuit Judge Edith Jones, a Ronald Reagan appointee, wrote for the majority. In July 2025, ICE announced in a memo that it was going forward all applicants for admission defined an immigration status as an alien present in the United States who has not been admitted or who arrives in the United States, which means they just crossed the border, right?
Okay.
They didn't say anything to anybody. They just came right
Just
on
jumped the
in.
border. Yeah.
Yeah. And deportation proceedings would be subject to mandatory detention. Bond hearings would be reversed only for immigrants who were admitted into the country but later lost their legal status, right? So again, overstayed the visa, overstayed the work visa, the school visa,
And so on. Yeah.
right, or work visa. A lot of them are work visas, right?
Right.
And then there's also been a lot of issues with American citizens not getting hired for things because they will hire those who have those visas. They don't have to pay them as much. There's a different pay scale for them, right? So this meant that all individuals who entered the country without being legally admitted, including those who were paroled into the country, which does not count as lawful admission, will be subject to mandatory detention and held without bond while they go through the removal proceedings, regardless of how long they've been in the U.S. So what this does is it removes the option for attorneys to represent people to get them out on bond, right? They don't get a bonding process. They just get deported, right? And
but they do have access to counsel when they are being held, I presume. They can bring a lawyer, I presume, if they're being held.
A barrister, a lawyer. So the deal is that you get due process, right? Citizens of a country have a different level of due process, right? Jury of peers for certain kind of civil cases and criminal cases, magistrates for other kinds of, say, family law stuff, which is a court of equity as opposed to a court of law. The court of immigration is an administrative court. It says administratively you have missed and we're going to have to send you back now, right?
Right.
So that there's different kinds of law, right? Again, civil, criminal, administrative, and courts of equity, right? So this is specifically an administrative court issue. And the other problem here is that the federal courts, the district court system doesn't generally have jurisdiction here because the immigration courts exist. And the Article 1 Congress has removed their ability to deal with immigration cases. And even if those cases get appealed, they get appealed to the appeals court. They're never at the federal district court. They are either at the immigration court or they're up into an appeals section, right? So those federal district court judges that are picking these up, right, are not supposed to be even touching them or messing with them because it's not their bailiwick. It's not their space, right? Congress says you don't do that anymore, which is a lot of them are just like, well, no, I'm just going to do whatever I want. I'm the law, as I said, and it's starting to get.
But 300 federal judges. That's a lot of judges. Wow, are disagreeing with it.
Right, but the deal is that enforcement of laws in the country is adjudicated by Article 2 executive branch, right? And if they have a law that says you shall do a thing, then federal supremacy kicks in and the states and local jurisdictions need to adhere to that. Like it or lump it, right? So it can be lawful but awful, but it is in fact the law, right?
Yeah.
So after reviewing carefully the relevant provisions and structure of the Immigration and Naturalization Act, the statutory history and congressional intent, we conclude that the government's position is correct, Jones wrote, joined by U.S. Circuit Judge Kyle Duncan, a Donald Trump appointee. The ICE memo resulted in a wave of habeas petitions in federal courts, according to the recent analysis. over 300 federal judges have ruled that the Trump administration's mandatory detention policy is illegal, only a handful siding with the administration.
Okay. Wow, that's a lot of judges. A lot of judges.
It is, but it doesn't mean that the verbiage is wrong, right? So the 5th District Court has made this determination, which again, its governing authority space is Texas and Louisiana. There is an appeal case up in the 8th District Court, which is important because that is the one which holds Minnesota and specifically Minneapolis under its sway, right?
Right.
So,
and what way is that swinging? Doesn't even know.
What does what mean now, Patrick?
What way is that court going to swing up in the 8th District?
Well, there's already been a determination by the 5th District Court. So if the 8th District Court goes in opposition and functionally makes it a mutually exclusive decision, right? Like here we do one thing, there they do another, then the case that disagrees or the one that does agree is more than likely going to end up at the Supreme Court, right? And the Supreme Court is functionally right now 6-3 conservative to liberal, which means that more than likely the 5th District Court's judges that made that determination are going to be the ones that hold through, which means that the 8th District will have to capitulate, and then immigrants who are in that space shall be held because they're in violation of
obviously this all takes time, I presume, weeks, months, and so on, for to go through all this process, I presume.
It seems like all the things that deal with Trump are going a hell of a lot faster. For whatever reason, to cause distress or whatever else. It just seems like they're moving a hell of a lot faster. When we were talking months ago about judges making decisions at 1 o'clock in the morning on a Saturday morning, that almost never happens. It's never really happened until this specific administration. Things are moving very, very fast. Good or bad, they're going way faster than I think is prudent. I don't know that people are rendering good decisions when they make the decisions this quickly, right?
Yeah, they seem to be held for leather. Is that the word I could use with a lot of their decisions? As you say, you've never seen it go this quickly, I presume, in all your years in the United States.
Well, all of my years, except for a couple overseas, have been in the United States, right? So I've never seen things go this fast, right? And we were watching Your Angry Friend, and he was rah-rah-rahing this thing, and it.
Yeah, we have to tell the audience who our angry friend is.
Attorney Andrew Branca, who is licensed to speak in front of the Supreme Court. But he is correct in that the verbiage says shall. And in a case where federal supremacy is a shall, then the lower courts, the state and local jurisdictions, county level, city level, should be adhering to that, right? If you pick somebody up and they are past their time or they have a final deportation order, you shall hold them without bond until such time as they are picked up to complete their process of final removal, right? So the two habeas petitioners in immigration detention in the case, one of whom came to the U.S. in 2009 and the other in 2001, argued in oral arguments Tuesday while they were applicants for admission, the statute's mandatory detention provision applies to people seeking admission. An ACLU attorney for the pair said they were not seeking admission to the country, but rather relief from removal.
Okay.
Well, make that make sense. Are you applying to be admitted, or are you seeking not to be sent out? It's the same thing.
Yeah, it's the same. Yeah, it's pretty much. Wow, that's pretty much the same thing. That's a very strange way of putting it.
Well, no, it's slippery language, right? It's either the front.
I'm reading it right. Yeah, I'm reading it right now. It's
either the front of the coin or the back of the coin, but it's still the coin, right? You're still pretty much saying the same thing. But wow. Okay. Well, they would have to apply for admission to stay.
Yes.
Okay. So if they're not seeking admission, then they're admitting that they're here illegally, at which point they should go. Like you can't. Yeah. But the panel's majority found that all applicants for admission are seeking admission. Right. Which is the logical way to go about it, right? If you're here, then you're seeking admission, but you're not doing it appropriately. You're not an applicant for admission. You are just seeking admission, right? They're obfuscating the language, and it's bad language, right? To the U.S., Jones likened the situation to someone applying for college. It would make no sense to say that as soon as the applicant clicks submit on her application, she is no longer seeking admission merely because she does not take any further affirmative steps to gain admittance. Instead, she would ordinarily be understood to be seeking admission as long as her application is pending. The same is true here. The petitioners are deemed by statute to be applicants for admission pending the resolution of removal proceedings. While they remain applicants, they are presently seeking admission. Right? That just makes sense, right? So, we're going to talk about the codes here for real quick as well. So, one of two federal statutes in the Immigration and Naturalization Act at issue is 8 U.S.C. Code 1225, which applies to applicants for admission. A provision of the statute states that an alien seeking admission who is not clearly and beyond doubt entitled to be admitted must be detained and put through removal proceedings. So if you're here illegally, we are obligated to start your process to put you through removal proceedings, right? So, and then 1226 governs deportation proceedings are more generally providing for discretionary detention and allowing the government to release detainees on bond while they go through their removal proceedings. Federal regulations give people detained under the statute the right to request a bond hearing before an immigration judge.
Yeah.
Right? So
it's well,
this says discretionary detention, but 1225 says it is not clearly and beyond a doubt entitled to be admitted. Right? So if it's unclear, you're amorphously here. You're just kind of here, living in the country.
Yeah, you didn't beam down from outer space. You had to come into the country somewhere.
Right. Yeah, it wasn't an accident that you made it here, right? Like you intended to be here, right?
Yeah.
So, U.S. Circuit Judge Dana Douglas, a Joe Biden appointee, highlighted the lower court's numerous opposing rulings in her dissent from the majority opinion. Now, the problem with that is she didn't say the verbiage says this, therefore, right? She cannot find it in the statute, right? So no matter what, this newly discovered mandate arrives without historical precedent and in the teeth of one of the core distinctions of immigration law. The overwhelming majority of courts in this circuit and elsewhere have recognized the government's position as totally unsupported. Based on the verbiage of 1225, they shall be detained, right? So the 1226 seems to be a little bit strange on that, right? So we'll look at that real quick again, right? It governs deportations proceedings more generally, providing for discretionary detention, right? It means they can choose to do one or the other, right? So if the administration wants to say, we're going to do it 1225, then we're going to do it 1225, right? It's not going to be discretionary detentions with bond hearings. It's going to be removal orders and you go, right? So he criticized the majority for their interpretation of Congress's general intent of the statutes instead of focusing on the text of the statutes. The majority stakes the largest detention initiative in American history on the possibility that seeking admission is like being an applicant for admission. It is. Once you cross the border, you are applying for admission. You've done it incorrectly, but you have applied by physically being habeas in the space, right? So, in a statute that has never been applied this way, based on little more than an apparent conviction that Congress must have wanted these non-citizens detained, some of them spouses, mothers, fathers, and grandparents of American citizens. Straining at a gnat, the majority swallows a camel, right? So the other problem with this is your familial relationship doesn't matter in regards to your citizen status. Those things are immaterial. You are either a citizen or not a citizen. Doesn't matter who you're related to. And if the 14th Amendment thing goes through with no more birthright citizenship, then all that goes away anyway, right? But that is a discussion for another day, right? The American Civil Liberties Union, which represents the two petitioners, did not immediately respond to a request for comment. Department of Homeland Security Kristi Noem wrote Friday on social media, for months, activist judges have ordered the release of alien after alien based on the false claim that DHS was breaking law. Today, the first court of appeals to address the question ruled that at DHS Gov was right all along, right? So that's Noem's policy to follow the direct of the administration. The administration says, I want this 8 U.S.C. 1225 to be adhered to, and I want all jurisdictions to follow the law as written this way, because of federal supremacy, it applies, right?
Why do you think there's such a pushback against it? A lot of parts of the United States.
Because that just ain't the way it's been done. We want discretionary hearings. We want bond hearings. We want all these things. But the thing is, when you release them on bond, return rate is very, very low, right? They pinky promise to show up and then they don't show up and then they're still here. And they're taking resources away from citizens who are due those resources. Taxpayers who've put money into the system. When people come in and don't pay taxes, right? You cannot have social welfare and unchecked immigration. Your country's your country's doing that right now, right? So you as an average citizen, you work, you've paid your taxes for, we'll say a couple of decades.
Many decades.
Right. So your blood, sweat, tears, and economy has gone into the local economy, and there are people who have not contributed, who are not citizens, who are coming in and they're extracting those resources from the body politic. Not appropriate. Right?
No.
So if we had no social welfare system here at all, cool, come on in. But you can't have both. Right? There isn't a country that can run on that. So, all righty. So that was from Courthouse News Service again.
Very well put together article, actually. Very straight to the point.
Ms. Wasbergen did an amazing job. So we have another article we're going to cover and a third one that's way more in depth that we're going to put in the show notes for you, so you can check that out and read it for yourself. We're also going to include the decision that was come to by that 2-to-1 decision in the 5th district, and then it's going to cause some issues. There's going to be a ruckus. So, all right, this one here is from ABC News, your favorite.
Okay, let's see what they have to say.
This one's
not. I have it up here myself as well. I'm looking at it right now.
All right, here we go. President Donald Trump's administration can continue to detain immigrants without bond, marking a major legal victory for the federal immigration agenda, encountering a slew of recent lower court decisions across the country that argue the practice is illegal. Well, we've just seen from the verbiage of that act from 1999 that it is not illegal, right? So it not being illegal means that maybe the 5th District panel was correct, right? So a panel of judges on the 5th Circuit Court of Appeals ruled on Friday evening that the Department of Homeland Security's decision to deny bond hearings to immigrants arrested across the country is consistent with the Constitution and federal immigration law. We've talked about it a little bit. It looks like, from our perspective, not being lawyers or solicitors, that it looks pretty good on its face, right? So prima facie, it looks pretty good. So specifically, Circuit Judge Edith H. Jones wrote in the 2-to-1 majority opinion that the government correctly interpreted the Immigration and Nationality Act by asserting that unadmitted aliens apprehended anywhere in the United States are ineligible for release on bond, regardless of how they have resided, how long they've resided in the United States. Again, overstayed their visa, there's a final deportation order, and they're just not coming in to execute that. They're just not leaving. Right?
I think the moral of this story is, if you ever want to go to any country, you should do it the right and proper way. And that, by the way, this is not just in the United States. People have to realize this is across most of Western Europe now at the moment. Is if you come in here and you land from a boat or a plane, you're not going to get a very warm welcome anymore. You either do it the right way or don't do it at all.
Right.
It's the message all across Western world at the moment.
Right. You said the Gardaí there, it's in Ireland, are folks up and moving them now, right?
Yes, we can actually see the headlines now. It takes a while, as I was saying to people, to ramp up all the infrastructure, train staff, get facilities in place and so on. But we are beginning to see the ramp up now. It'll probably be more towards the summer of this year. You'll see more of it as more and more staff come on board.
Well, you've had rain for a month straight. Nobody wants to go out in that regardless. So,
well, the weather as well.
All right. So, under past administrations, most non-citizens with no criminal record who were arrested away from the border had an opportunity to request a bond hearing while their cases wound through immigration court, right? So that's a bit of awkward language there, right? So if you are in violation of 8 USC, you have broken the law, right? Because you're in violation of the Immigration Act, specifically at this point, 1225, 1226, which indicates the kind of hearing that you would have based on that, right? So historically, bond was often granted to those without criminal convictions who were not a flight risk, and mandatory detention was limited to recent border crossers. Now, if you cross the border, it's illegal, right? But what they were
Yes.
looking for is another barrier or another obstacle to that, where if you do not have a criminal conviction in the United States, right, but you are already committing an act that is illegal per 8 USC, right?
You're already breaking the law by crossing the border illegally.
Right. But again,
Yes.
remember that it's an administrative court. It is not a criminal court. So
not a
what they're
criminal
looking
court.
for is not only are you in violation of the immigration policies, but you are in violation of other criminal policy, right? Penal code type stuff, right?
Yes.
So the prior administrations decided to use less than their full enforcement authority under the law. Does not mean they lack the authority to do more, right? So they can say under 1225, you will be detained and you will not get a bond hearing. They can say that. And that's what the judge is interpreted it to mean, which it very plainly states that to be the case, right? So the plaintiffs in two separate cases filed last year against the Trump administration were both Mexican nationals who had both lived in the United States for over 10 years and weren't flight risks, their attorney argued. Again, flight risk or not, they still have broken the law. Neither man had a criminal record, and both were jailed for months last year before a lower Texas court granted them bond in October. The Trump White House has reversed that policy in favor of mandatory detention in July, reversing almost 30 years of precedent under both Democrat and Republican administrations. Either way, that's not the verbiage of the act, right? So Friday's ruling also bucks a November district court decision in California, which granted detained immigrants with no criminal history the opportunity to request a bond hearing and had implications for non-citizens held in detention nationwide, right?
Right.
It seems strange, right? There's such a bifurcation in this country. It's crazy.
Yeah, there seems to be an awful lot of disconnect all over the United States when it comes to this policy, actually, isn't there?
Yeah, well, a lot of it has to do with bodies and places, because our electoral college and our House of Representatives are based on people in the space, not citizens in the space, right? So if I have, so each federal representative represents approximately 890,000 American citizens, right?
Right.
And that's quite a lot because we have 400 and some odd. There's a couple few of them, right? We've discussed it in the past. So if you have lots of people in the space, citizen or not, you'll get more seats in the electoral college, which will sway the election of the president, and you will get more representatives in the House of Representatives, which will cause there to be a mismatch, right? So places like California that have a few million illegals are going to have more seats than some places who are further away from the border that don't have these kinds of policies, right?
Yeah.
So, but that's looking at it from a bigger picture type of view. Like the more bodies you can fit in the space, the more representation you'll have, and the more power you'll end up with.
I think that's a good way of breaking it down Barney style for people as well, just to kind of understand the bigger picture behind some of these policies.
Right. The more bodies in the space, the more representation you get, the more electoral college votes you get, which means you can exert more power at the end of the day. At the end of the day, as they would say. So Circuit Judge Dana M. Douglas wrote the lone dissent in Friday's decision. The elected Congress members who passed the Immigration and Nationality Act would be surprised to learn that it also required the detention without bond of 2 million people. Douglas wrote, adding that many of the people detained are the spouses, mothers, fathers, and grandparents. Right, and we talked about that before. Your familial relationship with someone doesn't indicate your citizenship. How much you like something doesn't make it the best or right thing, right? I don't think you should put cold pineapple on pizza. That's just me.
I think this judge is trying to make people realize the knock-on effect of this policy. I think it's very easy to kind of dehumanize people, but sometimes, as you say,
well, something
you have to break a few eggs to make an omelet. Isn't that what they say long ago?
Right. Things can be lawful but awful at the same time. Right?
Yes, I know it's awful for the people involved, and I understand a lot of things are running hot at the moment over this entire policy.
Right, but
if
you didn't commit the illegal act on the front end, then there'd be no back end issue or problem. If you know you need to go and you can't figure it out for yourself, and 90% of them don't come back for their hearings once they're released on bond, then at that point, your laws are ineffective. The law is not performing the task as it was intended.
But when we see two individuals going into the court who are 10 plus years already in the United States working and obviously contributing, surely within those 10 years, they had the wherewithal or the resources to start the proper process of staying within the country
Right. Seeking
legally
asylum, going through the
and
process.
going through the proper process instead of just sitting there, just, I don't know, waiting for a passport to fall out of the sky or something. I don't know.
Oh, yeah. I think they do that. I think they fly planes over places and just drop passports everywhere.
Yeah, but the sad thing about all this, all jokes aside, is a lot of this can be solved by people realizing you cannot come into a country illegally anymore. Those days are gone across Western Europe. Immigration's got stricter rules. They're starting to deport people from Ireland all over the Western world.
Oh, for sure. And I think that it's good to note that if you do it the right way, then much better chance and a whole lot less resentment, right? A whole lot less resentment from the body politic, from the constituents in that space. If you work hard to assimilate and become a citizen and become Irish, maybe not you, but your kids, right? The culture, the people, the way. Same with the United States.
Is, as I said, same as, say, take Ireland, for example. It's the same probably in the United States. It is a long process to become a citizen of either of our countries. But it's a lot safer than just being picked up in the morning and losing everything you worked for and getting deported.
For sure. And that affects your family, right? It affects everybody around you. But the thing is with the policy we've had up to recently, the borders being so loose means we can't keep track. We can't vet anybody. We don't know if horrific people have come. And like Maduro said a while ago, and before him Chavez, we sent all our bad people to the United States. We don't have to worry about it, right? Like if you don't have a strong border, so a border represents a different in cultural identity, different in concepts of what is right and what is wrong. I love Mexico. It's a beautiful country, beautiful place, beautiful people, but it is not the United States, right? The UK, right? Britain is not Ireland. I don't want you here if you don't go through the proper procedures and processes to seek an assimilation and identify with our cultural norms and values. That is not the right answer, right?
It ends in a clash of cultures. It's not good for anyone involved, really, if I'll be honest with you.
No, it's not. So, all right, I'm going to show you all this last article. This one is from One First, and Steve Vladeck did a great job on this one. He discusses some judge shopping that might have gone on, which is pretty interesting. A lot of the left gets accused of judge shopping, which they do, which is why they end up in the DC circuit or they end up in Massachusetts or California in the 9th district. And you're going to find people on the right who are ending up in the 5th district in Louisiana and Texas and stuff like that. So, but this discusses a lot of that and a lot of the more right-leaning side of this, which is pretty interesting. So we'll go ahead and put all this stuff in the show notes. You got anything else for the people, Patrick? We good?
No, I think those articles summed up the decision quite well. I think, as they said, the moral of the story is just don't jump the borders, people. It's not worth it. It's not worth the hassle.
Yeah.
You are going to, no matter how many years you think you're getting away, but eventually you will get picked up. It's every time you go outside your front door, you're just rolling a dice. And it's not fair on you or your family if you do not do it the proper way. Because if you get picked up and say brought to one of these detention centers, you're sent to Texas, which is a couple thousand miles away in some cases from where you are.
Yeah. So I think here's the big one. Be a good faith actor. Find out what the right way is to do it and do it. Assimilate into the culture and be part of this great American or Irish thing or wherever it is you want to go. Contribute. You know what I'm saying?
Every country in Western Europe has different visa policies. Most of them are pretty complicated. Some of them are straightforward. Just, as I say, hire someone, do it properly. It's just not worth it. You're going to lose everything you worked for. Like these gentlemen here, for 10 plus years, obviously they've built roots, families, and whatever. Now they are going to be deported and probably never left back into the United States.
Pretty much. It's looking that way for them. All right. For Patrick McCallum, I am Alex Johansson. Like the ring the bell, do all the things to help us beat the algorithm. Subscribe. We will catch you on the next one. We are